After old business, that brings us to new business. With new business, there's no LRs, no JARs, so that brings us to bills. That brings us to the first bill, a bill for an act entitled an act to amend portions of the Crow Tribe Sex Offender Registration Ordinance required for compliance with the Adam Walsh Child Protection and Safety Act. The floor recognizes Senator Not Afraid of the Bighorn District. Okay. All right, they'll be passing out the amended red line version. For your information, we'll be discussing this bill, and then the next one is the Board of Horse Racing, and then we will adjourn for tomorrow to receive reports tomorrow from everyone. That's kind of what I was looking at, because it says introduced by Cedric Blakey, Chairman.
No, this is the one that's being amended.
Oh, this one being amended. Okay.
It just shows the red line where
Okay.
it shows that where it was inserted into the law where the amendment started. It should have a pretty
All right. With that, at this time, I believe this is the red line version that they're handing out. And I believe we have executive legal counsel here to represent the executive branch. Is that right? You're on behalf of the executive branch. So it's Kristen Burge, executive legal counsel. The floor now recognizes Kristen. You can come on up. Before you read this into on the record, are we just amending? Is this what we're doing? Is amending it? Or?
It's an amendment to bring the bill up to standard. I'll have Kristen
all right,
explain it more.
Why don't you just explain it, Kristen, and then we'll go from there, because I'm getting slightly confused because we have a bill from July 2009 introduced by Cedric Blakey, Chairman of the Executive Branch, who's no longer chairman. So if we want to maybe just tear that page off so we're not all confused, we'll take the first page off. Disregard the first page.
I'll explain.
Okay. All right. Floor organizes Kristen Burge.
Thank you, Mr. Speaker. The red line version that was handed out, it's a red line version of the 2009 legislation. That's why it has the former chairman's name on there. It was to show the changes that are being proposed. So the bill, which was submitted to the legislature, is for the January 2013 session, and it's an act to amend portions of the 2009 Crow-SORNA law, which is a Sex Offender Registration and Notification Act. In a nutshell, we were notified by the Department of Justice regarding SORNA and a review of the Crow Tribe SORNA law, which is the 2009 law, which was passed. and that there are certain portions of that law that have been changed, mainly changing certain offenses, making more severe penalties for some offenses, adding a few offenses, adding a provision for international travel. So if a sex offender goes on travel internationally, that we have to let that jurisdiction know. And essentially what the SORNA law, it's a federal law which required the states to implement sex offender registration and notification. So they have a whole set of provisions and laws that they have to follow. And Indian tribes could elect, if they wanted to implement sex offender registration notification within tribal jurisdiction if they wanted to. If not, the state does it. And the tribe had elected to go ahead and do this within tribal jurisdiction instead of having the state do it, so that, you know, the tribe exercised its sovereignty and said, we want to do this within tribal jurisdiction. But in order to do that, we have to have a tribal law that meets federal standards. And so these amendments are required. We've been notified by the Department of Justice that they're required to amend our Crow-SORNA law so that they're in compliance with the federal SORNA requirements. And like I said, they're pretty minor. It's adding a few offenses, re-tiering some offenses, and adding like an international travel section, and also I think like an acknowledgement form on here. There are some other issues that have to be addressed before we become substantially compliant with the federal SORNA requirements, but most of that is non-legal, and it's being handled by the SORNA officer at law enforcement, who's doing the website, uploading the information. They have to, there's a lot of stuff regarding the implementation, but most of it is not you know, something that has to be changed in the law. This is the legal portion that we have to address. So that kind of gives a brief summary. I hope that answers your questions regarding what this is about. And we would have been working with the subcommittee a little bit longer and more in advance if we had known, but the former prosecutor was the point of contact for this, so I kind of just was brought in the last minute when she left the tribe and was asked to look at it to make sure that we can get implementation, because our deadline was January 27th, and that's what it says on the front of the bill. I've talked with the Department of Justice, and we were able to get an extension till April, and that wasn't so much for the law part, it's more for law enforcement, to give them enough time to get everything uploaded in the website and do all the things that they need to do, so that this doesn't get delegated to the state. So that's the reason I was really quick in trying to hurry and get this in the January session, because I thought we were still under that January deadline.
All right, so thank you for explaining that to us. So now we're just going to ask that you read the heading, and then we'll ask for a motion to adopt after you read the heading.
Introduced by Darren Old Coyote, Chairman, Crow Tribal Executive Branch, a bill for an act entitled, An Act to Amend Portions of the Crow Tribe Sex Offender Registration Ordinance Required for Compliance with the Adam Walsh Child Protection and Safety Act. Whereas the United States Congress enacted the Adam Walsh Child Protection and Safety Act in 2006, and whereas the stated purpose of the Adam Walsh Child Protection Safety Act is to protect children from sexual exploitation and violent crime, to promote internet safety, and to honor the memory of child victims such as Adam Walsh, and whereas Title I of the Adam Walsh Act is known as the Sex Offender Registration and Notification Act, or SORNA, and whereas the federal government has mandated that the states shall have the obligation to participate in a national sex offender registration program meeting the requirements of SORNA on behalf of tribal governments located within a particular state, unless the tribal government elects to participate in the national registration program and to meet the requirements of SORNA. And whereas the Crow Tribe elected to participate in the National Sex Offender Registration Program and to function as a registration jurisdiction in order to maintain its sovereign right to manage its law enforcement programs without interference or direction by the state of Montana through CLB 07-12, which was signed into law on July 19th, 2007. And whereas the Crow Tribe is required by the terms of Title I of the Adam Walsh Act to adopt legislation to fully comply with the requirements therein, and whereas the Crow Tribal Legislature passed the Crow Tribe Sex Offender Registration Ordinance CLB 09-05 unanimously in July 2009 in order to comply with the requirements of SORNA, and whereas the current Crow Tribe Sex Offender Registration Ordinance must be amended in order to comply with the updated requirements of SORNA by January 31st, 2013, to avoid delegating the Crow Tribe's election to participate in SORNA to the state of Montana. Now therefore be it enacted by the Crow Tribal Legislature, Section 1, that the amendments attached hereto and incorporated herein by reference are approved and shall be codified in the Crow Law and Order Code under Title 8D, Crow Tribe Sex Offender Registration Ordinance. Section 2. These amendments shall become effective immediately upon enactment by the Crow Tribal Legislature and approval by the Chairman of the Executive Branch.
All right, we move into the 30-minute presentation by the sponsor, and then you can give another brief explanation on the bill.
Like I said, this is not my area, but I'm just trying to make sure that we fulfill the requirements that need to be addressed in order for us to maintain jurisdiction over this area of the law, which would be sex offender notification and registration. From what I can gather from going through the file, which was a big, huge box full, the tribe has made significant steps in getting to that point. We are not at substantial implementation yet. We have to address these outstanding issues. There's about 10 issues after DOJ reviewed the Crow Tribe submission, which was done in June of 2011, and I've been in contact with our point of contact at the DOJ, her name's Juliana Grant, to go over exactly what we need to do to make sure that we get substantial implementation. She thinks there should be no problem in the tribe achieving that by the extension of April 27th, and I've assisted Kevin Howe with law enforcement to get him an administrative assistant because we have a SORNA grant. So there's funds available to hire an administrative assistant to help him make sure that all of this gets done by the deadline and we don't end up delegating to the state. There's a few things in the submission that have to be tweaked, very minor things, but most of it has to deal with the actual work of getting all the names of the sex offenders within tribal jurisdiction, uploading that, and also having relationships with other jurisdictions to make sure that we're sharing that information. So that's the bulk of the work that has to be done, and that's why I assisted to help them get an administrative assistant so they can get started with that. But it sounds like they have at least the structure in place, and it's a matter of getting those files done. The law part of it, in the DOJ's review of our tribal law, these were the only issues that they noted. There is a model tribal SORNA, and there's a lot more in there, but they said that our law suffices as is, except for these provisions. And some of these things were actually changed after we adopted our law. So Crow adopted SORNA and passed it in 2009. With all the requirements from DOJ at the time, they actually ended up making some changes after the fact in 2011, and that's how we ended up with these amendments that now need to be incorporated. Let's see. I don't know if there's anything else. I think I went over all the changes we're adding. I can just go through a couple of these. One is like with interstate travel, like arranging, inducing, procuring, or facilitating travel and interstate commerce of an adult or a minor for the purpose of engaging in illicit conduct for financial gain. So those are a couple of offenses that were added. And I'm just looking at the red line version because it kind of shows they add some sexual acts and sexual abuse of minors in some sections, and then there's the international travel requirements. So if a sex offender travels outside of country that we're to notify that jurisdiction, and the other one was a sex offender acknowledgement form, which is kind of in the policies and procedures of what law enforcement would be doing, that they also wanted in our law as well. But that the sex offender shall have rights, that they should have the form read to them, that they are acknowledging that they're being registered as a sex offender and they have to sign it, and so on. But that pretty much sums it up.
Okay, thank you. We're still in a 30-minute presentation. Floor recognizes Secretary of the House, Okro.
Thank you, Mr. Speaker, members of the body. What I asked Kristen to do was provide the SORNA, the actual SORNA that we were amending. The bill here shows all the amendments, and I wanted her to insert them into the actual SORNA, and that's the red line version. That way you could see where the amendments are inserted into the SORNA, and that's why Chairman Not Afraid of the Bighorn District thought it was a good idea to implement that and then to hand it out now during this session rather than before, because as you know, sometimes papers walk away and we lose them. But anyway, that way we can read it. The amendments are here in your packet, and it's inserted into the actual SORNA standards here. And like what Kristen was saying, this is only the minimum standards that are there. There can be more that we could insert, but she was pretty much pressed for time because of the deadline. That's why we're implementing just up to the standards at this point, right? And we can do more later. Like Legal J there mentioned that there was so many other things that we could implement. And I kind of mentioned to him that, we can do that, but we can do that at a later date. But right now, we want to at least meet the standards at this point in time. But that's what I just wanted to point out. Thank you.
Okay, thank you. We're still in a 30-minute presentation. All I can note is that if you look in the handout, it is, the red line is what's inserted. And that's what the changes are to the law. And what we're basically doing here is just bringing ourselves up to speed, our reservation, so that we're staying with the federal regs, right? Right, Chris? So we're still in 30-minute presentation, though. Okay, in-house counsel for legislative branch has a question, so floor recognizes Jay Harris, in-house counsel.
Thank you, Mr. Speaker, Mr. Secretary, members of the legislature, members of the Crow Tribal General Council, watching our proceedings on the internet, Executive Branch Legal. There was a couple things I wanted to point out. First of all, I wanted to thank Secretary Okro for clarifying that the handout we received was simply the amendments that are being proposed in context. I think that's really good practice so that you can see where it fits into the legislation that had been passed back in 2009 July session. I was in the mistaken understanding that there was amendments to the proposed amendments. Perhaps some senators had thought that as well, the way that they were presented. I apologize for my misunderstanding on that. Questions I've got, well, first of all, I would point out, and I wouldn't be doing my job if I didn't point this out, that we know that the gold standard of our legislation that's passed is whether it's consistent.
Excuse me for a second there. Right now, we're in the 30-minute presentation, so it's for those who are proponents of this legislation. I believe your questions can come up during the debate portion. After we hear from the chairman of the committee, then the debate, when the debate comes out, then your questions can come out.
Okay.
Because right now we're in a 30-minute presentation, so right now it's for the people who are proponents of this legislation.
Okay.
Okay.
Speaker, with due respect, we're following the rules very closely. Rule 32 does govern what's happening right now, and I don't think we're following Rule 32, but I just make note of that. Thank you.
Okay. All right, so we're still with 30-minute presentation. Going once. Going twice. Going 3 times. We move on to the next. And that's calling for the chairman, which is, this legislation is in the Judicial Committee. And the chairman of the Judicial Committee is Senator Not Afraid of the Bighorn District. So the floor now recognizes Senator Not Afraid for your approval or disapproval.
Thank you, Mr. Speaker, Secretary, Vice Chair, legislative body, and no visitors. We had a meeting, judicial subcommittee meeting in a speaker's chambers. We had a dual committee meeting at that day. With the other meeting was being held in here by Natural Resources Committee, and members present were Senator Leroy Not Afraid, the Judicial Secretary Knut Okro, Senator Pretty Payne, and myself, along with Judicial Tribal Court Christina Nomi and Chief Judge Julie Garlett. During the meeting, Executive Council had stated that she explained the new provisions enacted by Congress that we, as a jurisdiction, pro-tribal jurisdiction, had to apply to the new law, that so we don't have to be directed by the state of Montana. So that's where we're at today, and Senator Leroy Not Afraid had made a motion on the floor. To go ahead and present this and read into record and pass to be read into record, and seconded by Jeannie Pretty Payne, and the body voted unanimously for passage. Thank you.
So you recommend approval, am I correct, Senator Not Afraid?
Yes, sir.
Okay, we have a recommendation for approval. Floor is now open for debate, and now we move to in-house counsel, Mr. Harris, with his question. Before he answers the question, he mentions Rule 32. Rule 32 is coming with a letter of authorization to represent the executive branch, namely the 4 officials. But at this time, due to the fact that we're dealing with a new administration, as Speaker of the House, I think that along with your guys is okay. I think it's okay if we let them go with this one time, but under the understanding that when you represent the executive branch, you have to come with a letter giving you that authority to act on their behalf. And that's Rule 32 in our Robert's Rules of Order. But we'll let it go today just due to the fact that it's a new administration. This is our first regular session. So with that, go ahead, Mr. Harris.
Thank you, Mr. Speaker. I think that's fair and reasonable for sure, and it's really not a burdensome rule, I don't think, to comply with, and it's for the benefit of everybody. I'll continue. I don't think I would be doing my job if I didn't bring this to the attention of the body. The gold standard of legislation we pass here is that it be consistent with the Crow Tribal Constitution's legislation is not. Section 8, Chapter 8, it does provide for a $5,000 per count violation sanction that is unconstitutional. It would be struck by the courts. As such, it's not going to throw out the entire legislation. Obviously, I'm believing a court would probably reduce it to the constitutional limitation of $1,000, which is contained in our Article 11. Better yet, legislature would make the amendment on the floor today to reduce the possible fine that would be imposed for violation to $1,000, making it therefore consistent with Article 11 of the 2001 Crow Tribal Constitution and eliminating any potential challenge on that grounds. I wanted to make that note. The only question I've got really, I want to point out too that it wasn't Congress that had changed the standard, it was the Attorney General through the delegation of authority that came from Congress in 2006 when they passed the Adam Walsh Child Protection Act. The Attorney General was given an authorization to establish guidelines. They're called guidelines, but they are requirements for any jurisdiction that would seek to elect participation in the SORNA registry, and the Crow Tribe passed legislation in the summer of 2009 that unfortunately as of yet is unimplemented, but we're taking a great step forward by passing the legislation that would meet the requirements of the Attorney General's guidelines that came out in January of 2011 after tribal consultation. Executive legal, I think, of course, adequately explained that both before the committee and then as well today. So my question, I'm finally getting to it, is this body, after passing the SORNA legislation that we have now before us with the proposed amendments, in October of 2009 passed legislation that established a Crow Tribal Department of Public Safety with very broad law enforcement authority. It's the most powerful tribal agency insofar as law enforcement authority is concerned. It specifically has the authority to enforce all provisions of the law and order title in which the SORNA legislation is to be codified next time around whenever a law and order code is to be published. My question is pretty straightforward. We had the tribal prosecutor that was making efforts to implement SORNA, had apparently submitted something 6 months after the Attorney General's revised guidelines. It wouldn't have been approved on arrival. If my understanding is correct, it was in July of 2011 that the submission was made, even though our law wasn't strong enough. My question is, the Department of Public Safety has the enforcement responsibility for this law. I'm wondering what the executive interpretation of that is, what the role of the Department of Public Safety is going to be with the SORNA registry. It's a key question because this legislature has the authority to confirm the director of the Department of Public Safety. It's a very important position. I call it the Sheriff of the Crow Reservation. You need an adjudicated background check, handgun certification, etc. It's a very important tribal position. It's never been filled. The chairman of times past has never gone so far as to make a nomination to this body for confirmation. The question, Mr. Speaker, would be to the representative of the sponsor of this legislation as to what the role of the Department of Public Safety is going to be with the SORNA registry once it is approved by the Department of Justice, and what the interplay is going to be between the tribal attorney general, tribal prosecutor, the Department of Public Safety, and the designee point of contact, Kevin Howe. I'm trying to get a feeling about how this is all going to work. I'm wondering if executive has a clear understanding as well. I think it would be very important for the senators to understand that as well. Because if there is any need, we can of course address the law right, excuse me, right now through amendments or future amendments, as the Secretary had mentioned.
Okay, we're still in the debate portion. Do you have a response for our in-house counsel? All right, floor organizes Executive Legal Counsel Kristen Birch.
Thank you. I appreciate that, Mr. Speaker. As to Mr. Harris's questions, I wish I could provide more information. I'm kind of just taking care of this in the interim until we have a full-time prosecutor that's going to be hired who'll be taking over this area. I've had pretty limited information interaction regarding SORNA. Mainly it was just to get these amendments passed so we don't delegate our authority to the state of Montana, and also to work with Kevin Howe just to help him get substantial implementation. But these are good issues that are raised, and I will have to consult back with the chairman and the officials and find out who's going to be in charge of this area to get you more information.
Thank you. We're still in the debate portion with this legislation. Any more debate going twice? Floor organizes Senator Covers up of the Lodge Grass District.
Thank you, Speaker. On this public safety issue, we should get a definition from the dictionary or from the law books and see what the explanation is, because public safety is just arm's reach of a town or a township or that kind of stuff that's interpreted in the law dictionary. So if they want to get into something in that area and to be recognized as an agency of the tribe, then they should have something a little bit more broader and more explanation to their enforcement power. So that was my kind of a question before, and I was asking. So I think we need to really look at that wording, public safety, you know, and that's just something for a township. So, we gotta look at the interpretation of this public safety issue too. So that was my concern before. So if they want to be a nation, they should have more of a department of justice or something of that nature to really be recognized. Because you're getting to the realm of the recommendation from the Department of Justice to pass something like this. So you have to have a stronghold to assert your rights as a nation. So that's all I got to say. Oh.
Thank you. Before we recognize the Secretary of the House, Okro.
Thank you, Mr. Speaker. One of the things that our legal assistant here provided information to me was, that I relayed to you, is in CLB 09-09, Department of Public Safety, and I think it is very important that we get a public safety officer confirmed here as soon as possible, unless there is one now that we don't know yet. Anyway, it says in Title 8F, Department of Public Safety, Part 1, Section 1, Subsection B, it says, first I'll read 1, it says, there is hereby established a Crow Tribe Department of Public Safety with a responsibility and duty to. And in B, it says, provide the general criminal provisions of the Law and Order Code as set forth in Title 8B, Crow Criminal Code as amended, Title 8C, Traffic as amended, Title 8D, Sex Offender Registration, Title 9, Juvenile Code as amended, Title 12, Fish and Game as amended, and any other criminal laws duly enacted by the Crow Tribe. So.
Thank you. We're still in the debate portion. Going once. We're still in debate, going twice. All right, so going 3 times. I guess we're done with debate. Now we'll open the floor for any recommendations or motions for amendments to vote on. There is none. Going once. No amendments. No motions. Going twice. All right, going 3. Floor recognizes Senator Not Afraid of the Bighorn District.
Thank you, Mr. Speaker. Question of privilege. Are we at the amendment part?
Yes, we are at the amendment parts right now.
Okay, now what we're doing is amending part 2, the SORNA bill, and I think that's where we need the sponsor to go ahead and go through the amendment part one at a time.
All right, so are you requesting that she go through and read all the amendments that are going to be inserted into SORNA now?
Yes.
Okay, so at the request of the chairman of the Judicial Committee, we're going to ask the executive legal to read the amendments. You don't have to read the whole thing, but just what's amended and what the insertions are, and then we'll go on from there. So floor recognizes Kristen Burge, Executive Legal Counsel.
Thank you, Mr. Speaker. And I'll be working off the red line version because hopefully it'll be easier to see where the amendments are. It's in chapters 3 and 4 are the only places where there's amendments. So it's a few pages back, about 5 pages back. The first page of chapter 3, it says tiered offenses. And it would be section 3.01, tier 1 offenses. Sub D, certain federal offenses. Conviction for any of the following federal offenses shall be considered a conviction for a tier 1 offense. And a tier 1 offense was added under sub 9, which is 18 USC section 2423D, arranging, inducing, procuring, or facilitating the travel in interstate commerce of an adult for the purpose of engaging in illicit conduct for financial gain. On the next page, actually the bottom of that page, it's section .02, tier 2 offenses, sub B, offenses involving minors. A tier 2 offense includes any sex offense against a minor for which a person has been convicted, or an attempt or conspiracy to commit such an offense that involves, and sub 3 was added, a non-forcible sexual act with a minor 16 or 17 years old. The same section 3.02, tier 2 offenses, sub C, certain federal offenses. Conviction for any of the following federal offenses shall be considered a conviction for a tier 2 offense. Sub 2 was changed. What was currently in sub 2 was moved to the next section, and this part was added. Section 18 USC, or 18 USC section 2423D, arranging, inducing, procuring, or facilitating the travel in interstate commerce of a minor for the purpose of engaging in illicit conduct for financial gain. Then it's section 3.03, tier 3 offenses, sub C, certain federal offenses. Conviction for any of the following federal offenses shall be considered conviction for a tier 3 offense. And the following sub 3 was added, which was changed from the last one, so it went from a tier 2 to a tier 3 offense. Section 3, 18 USC, section 2243, sexual abuse of a minor or ward. And then in chapter 4, it's a few pages in, it's section 4.18, international travel. Sub A, travel abroad. Sex offenders must inform their residence jurisdictions 21 days in advance if they intend to travel outside of the United States. Jurisdictions must notify the U.S. Marshal Service and immediately notify any other jurisdiction where the sex offender is either registered or is required to register of that updated information. The following sections were renumbered: 418, 419, and 420. 422, 421, 422. Section 4.23 was added, sex offender acknowledgement form. Sub A, the sex offender shall read or have read to them and sign a form stating that the duty to register has been explained to them by the Crow Tribe Sex Offender Registry and that the sex offender understands the registration requirement. Sub 1, the form shall be signed and dated by the Crow Tribe Sex Offender Registry personnel registering the sex offender. Sub B, the acknowledgement form shall be immediately uploaded into the Crow Tribe Sex Offender Registry. And those are all of the amendments.
Thank you. And those are the amendments. So, Senator, not afraid of the Bighorn District.
Thank you, Mr. Speaker. So now with all the amendments read, I make that motion for them amendments.
For organizers, Secretary of the House, Oak Crow.
Wanted a point of clarification. Jay, could you explain that this isn't actually an amendment to what's being introduced, but it's actually an amendment to the original bill? That we don't really need to do that amendment?
Well, thank you, Mr. Secretary, Mr. Speaker, if I could. I think I explained it pretty well. The chairman is introducing legislation per his constitutional authority, introducing it to this body to amend the currently existing law in order to make it compliant with the Attorney General's guidelines for implementation of SORNA nationwide. All jurisdictions have to meet these requirements. So that's the amendment. It's the amendment to the current tribal law that was passed in July of 2009. and there haven't been any proposed amendments to that legislation that would amend what was passed in July of '09. The House Rules procedure that we're in right now would be entertaining those amendments to what the chairman introduced, but no such motions have been made. Therefore, we still have the original bill that the chairman had introduced, which itself is an amendment to existing law, but to which no amendments have been made. I think I'm probably talked a little bit too much, but your explanation was better.
Yeah, so for a point of clarification, Senator, not afraid, there's no need for amendments because the chairman is reintroducing this bill, and there's no need for amendments because he's already making the amendments himself to his own, to the executive branch's previous bill. So there's no need for us to make the amendments on this side. For organized Senator Stewart.
So is this, just for clarification purposes, is this gonna be a proposed substitute?
No, it's not. It's a new bill, and it's a new bill being presented to the body with the new laws in it, which are required in order for us to receive any type of funding in the future or anything like that. That we have to have these laws in place before we can be considered for anything. So it's a new bill, and we don't have to go into the amendment process for anything on this. All we have to do is just vote on it. So at this time, I'm going to call for a motion to waive second reading and go to final roll call vote. All right. So a motion to waive second reading, go to final roll call vote. This motion is made by Senator Stewart. Do we have a second? Second by Senator Covers Up. Question? Question by Senator Not Afraid. All those in favor of waiving second reading, going to final roll call vote, please raise your right hand. Thirteen, yes, with no other senators in the chambers. That'll leave us with a 0 opposed and 0 abstaining. So that'll bring us to the final roll call vote, starting with Senator Pretty Paint. Go ahead, Senator Pretty Paint.
Pretty Paint, Black Cloud, yes.
Stewart, yes.
Not Afraid, Oshpot H.A., yes.
Robert LeBlanc, yes.
Alden Bighorn, yes.
Not Afraid, Bighorn, yes.
Bighorn, yes.
Big Green, yes.
Zero Creek, yes.
Rover, Mighty Few, yes.
Backbone, Mighty Few, yes. Old Cross, yes.
Shane Reno, yes. With a count of 13 yes, 0 no, 0 abstaining, the bill passes with a vote of 13 yes. Would you like to say a thank you? We have the executive branch. Floor organizes in-house counsel, Kristen Burge.
Just want to say thank you to all of you for doing this on such short notice. Really appreciate it. I apologize again for the short notice. We did get an extension, but we didn't find out until beginning of January, so we had to get this bill in December. So it was a little bit quick in getting it through, but appreciate you all looking at this and getting it done in a timely fashion. And I know that law enforcement is working really hard to make sure this gets implemented for the tribe as well too. So thank you.
Thank you. That takes us to the next bill, an act entitled Rules and Regulations of the Crow Board of Horse Racing. So with that, I believe the legal that's handling this is not here. I guess I'll have to ask the vice chair if he's willing to read this into record, or does he want the legal representative that's here already to read it into record? I believe, okay. Vice chair is going to read this into record. For organized Vice Chairman Dana Wilson.
Thank you, Mr. Speaker, members of the body. January 2013 Crow Tribal Legislature, Bill number CLB 10 introduced by Darren O'Kyle, Chairman, Crow Tribe Executive Branch, a bill for an act entitled Crow Board of Horse Racing Act. Whereas horse racing is an important traditional activity of the Crow people, and whereas simulcast and parimutuel wagering are Class 3 gaming activities under the Indian Gaming Regulatory Act, and whereas the Crow Nation desires to provide regulatory framework within tribal jurisdiction for horse racing activities on the Crow Reservation, and whereas such regulation is also necessary for sanctioning by the American Quarter Horse Association, and whereas an amendment to the Crow-Montana Gaming Compact allowing Class 3 simulcast and parimutuel wagering throughout the reservation under the regulatory authority of the Crow Board of Horse Racing has been approved by the state of Montana and by the United States Department of Interior, and whereas sanctioned horse racing under tribal jurisdiction does not exist anywhere in the United States, giving the Crow Nation an historic opportunity for exercising sovereignty and self-government in this arena, and whereas a strong and well-respected regulatory program for sanctioned racing and wagering will strengthen Crow horse breeding and add to the possibilities for economic development on the reservation, and whereas the chairman of the executive branch has authority and responsibility pursuant to the enumerated powers in Article 4, Section 5, Subsection B of the Constitution and bylaws of the Crow Tribe of Indians to, quote, appoint committee members to executive branch committees, and further the enumerated powers of the executive branch in Section 3, Subsection B, the power to administer and oversee all function of the executive branch, and whereas the legislative branch of the Crow Nation has authority and responsibility pursuant to its powers and duties set forth in Article 5, Section 2, Subsection C of the Constitution and bylaws of the Crow Tribe of Indians to, quote, adopt legislation not inconsistent with this Constitution, which is necessary in exercising the duties conferred upon the three branches of government, end quote. And whereas the combined actions of both the executive and legislative branches of the Crow Nation will create statutory support and regulatory framework for sanctioned simulcast and parimutuel racing on the reservation. Now therefore be it enacted by the Crow Tribal Legislature. Section 1. Adoption that quote, Crow Board of Horse Racing Act, unquote, attached hereto and incorporated herein by reference is approved and shall be codified in a separate section of the Crow Law and Order Code, except that the amendments of Title 23 of the Crow Law and Order Code shall be codified in that section. Section 2. Effective date that this act shall be effective immediately upon its enactment and approval by the chairman of the executive branch. Crow Board of Horse Racing Act. Section 1. Purposes of the board. The Crow Board of Horse Racing shall A. Exercise licensing, policy making, and regulatory functions. B. Submit its budget request to the tribal chairman. C. Submit reports required of it by law or by the tribal chairman. And D. Promulgate rules for the operation of sanctioned horse racing on the Crow Reservation. Section 2. Duties of the Director. The Crow Board of Horse Racing operates under the purview of the Director, who shall A. Direct and supervise the budgeting, record-keeping, reporting, and related administrative and clerical functions of the Board subject to Board approval. B. Draft the Board's budgetary requests. C. Collect all revenues for the Board and deposit them in a proper fund or account. D. Provide staff for the Board. E. Cause to be printed and distributed for the Board any required notices, rules, or orders adopted, amended, or repealed by the Board. F. Supervise race meets and activities of racing officials. G. Hire all racing officials. H. Inspect race facilities. I. Prescribe the duties and salary of stewards and J. Perform other duties as directed by the Board. Section 3, Board Membership. The Crow Board of Horse Racing shall A. be composed of 6 regular district members, in addition to the director, appointed by the tribal chairman who must be registered voters of their districts. B. Members shall serve for terms of 4 years with initial terms of 2 years for the representatives from Mighty Few, Center Lodge, and prior districts in order to stagger the terms. A member may be removed from office by the tribal chairman for cause. C. An incumbent board member may be reappointed by the chairman. A vacancy on the board must be filled for the unexpired term by the appointment of the chairman. D. The presiding officer is the director appointed by the tribal chairman. E. 2 members of the board, if all members have been notified at least 24 hours before a meeting, constitute a quorum for the transaction of business by the board. The director is counted for purposes of establishing a quorum. F. As provided in the tribal budget, the board may incur costs, charges, and expenses including travel reasonably necessary to carry out their duties. G. Board members who are not tribal employees may be paid $50 for each day in which the member is actually working for the board. Board members who are tribal employees may be paid if it is necessary for them to work after business hours and on weekends. Section 4. Reporting requirements. A. The board shall keep detailed records of board meetings, of the business transacted at the meetings, and license applied for the issued. B. Records of the board kept by the department are public records subject to public inspection. Section 5. Rulemaking function. The board shall adopt rules to govern race meets and the pari-mutuel system. These rules shall include the following. A. Definitions. B. Auditing. C. Supervision of the pari-mutuel system. D. Prevention of corrupt practices. E. Supervision, duties, and responsibilities of the director, the board members, the presiding steward, the racing secretary, and other racing officials. F. Licensing of all personnel who have anything to do with the substantive operation of racing. G. The establishment of dates for race meets and meetings in the best interests of horse breeding and racing on the Crow Reservation. H. The veterinary practices and standards which must be observed in connection with race meets. I. Absolute responsibility of trainers for the condition of horses and mules regardless of the acts of third parties. J. Licensing or renewal of a license of a person whose license has been suspended by the board or another horse racing jurisdiction. K. Setting license fees commensurate with the cost of issuing a license. L. The time, conduct, and supervision of all simulcast races and pari-mutuel betting on simulcast races. And M. Licensing, approval, and regulation of simulcast facilities. Section 6. Authority of the board. The board shall license and regulate racing and review race meets held on the Crow Reservation. All percentages withheld from the amounts wagered must be deposited in the board's agency fund account. The board shall then distribute all funds collected to live race persons or for other purposes for the good of the existing horse racing industry. Any new race-related gaming, including pari-mutuel and simulcast, will be examined and public hearings held to determine the effects of these forms of racing on the existing racing program. Indian relay and rodeo on the Crow Reservation. The board should consider both the economic and safety impacts on the existing racing and breeding industry. Section 7. Office and staff. The director of the Crow Board of Horse Racing will be assigned office space within the executive branch and 1 administrative assistant. Section 8. Race meets. It is unlawful for a person to hold a race meet, including simulcast race meets under the pari-mutuel system, on the Crow Reservation without a valid license issued by the board. A person applying for a license to hold a race meet under this chapter shall file an application with the board, which shall set forth the time, place, and number of days the license will continue and other information the board requires. B. A person who participates in a race meet shall be licensed and charged an annual fee set by the board, which shall be paid to the board and used for administrative expenses. Each person holding a license under this chapter shall comply with this chapter and with the rules adopted and others issued by the board. C. A license may not be issued to a person who has failed to pay the fees, taxes, or money required under this chapter. D. Applications to hold race meets shall be submitted to the board and the board shall act on applications within 30 days. The board is the sole judge of whether the race meet may be licensed and the number of days the meet may continue. E. The board shall require that a fair board and independent racing association conducting race meets meets the requirement of the rules adopted by the board before granting a license. F. A racing association consisting of a local fair board or an association approved by a local fair board may apply for a license to hold a simulcast race met in a simulcast facility. G. An unexpired license held by a person who violates this chapter or who fails to pay to the board the sums required under this chapter is subject to the cancellation and revocation by the board. Section 9. Penalties and judicial review. A. A person holding a race meet or an owner, trainer, jockey, or groom participating in a race meet without first being licensed under this chapter, or a person violating this will be prosecuted under applicable law. Racing that would qualify as a bushmeet or Class 1 racing under the Indian Gaming Regulatory Act does not fall under this act. B. The board, or upon the board's authorization, the board of stewards or a race meet at which they officiate may exclude from race courses at Crow a person whom the board considers detrimental to the best interests of racing as defined by the rules of the board. C. As its own formal act or through an act of a board of stewards of a race meet, the board may suspend or revoke any license issued by the department to a licensee and assess a fine not to exceed $1,000 against a licensee who violates any of the provisions of this chapter or any rule or order of the board. In addition to the suspension or revocation and fine, the board may forbid application for relicensure for a 2-year period. Fines collected under this subsection must be deposited in the general fund. D. The board shall promulgate rules implementing this chapter, including the right to a hearing for individuals against whom action is taken or proposed under this chapter. The rules may include provisions for the following. 1. Summary imposition of penalty by the stewards of a race meets include a fine and license suspension subject to review by the board. 2. Stay of the summary imposition of penalty by either the board or board of stewards. 3. Retention of persons pending final disposition of complaints, protests, or appeals of stewards' ruling. 4. Setting aside of up to 3% of exotic wagering on bets, including simulcast races, to be deposited in the board's agency fund account. The board shall then distribute all funds collected under this subsection to live race purses or for other purposes that the board considers appropriate for the good of the existing horse racing industry. 5. Using 2% of exotic wagering on live racing to be immediately and equally distributed to all persons except stakes races. 6. Assessment of penalty and interest on late payment of fines which must be paid before licenses are reinstated. 7. Definition of exotic forms of wagering on races to be allowed. 8. Standards for simulcast facilities. And 9. Conduct and supervision of simulcast races and pari-mutuel betting or wagering on simulcast races. E. The Crow Tribal Court has exclusive jurisdiction for judicial review of cases arising under this chapter. F. Conflict of interest. The director and board members will remove themselves from any hearing in which their interest is at stake. And be it further enacted that the Crow Tribal Gaming Ordinance be amended as follows. Section 10, subsection C, duties and powers. With the exception of pari-mutuel and simulcast racing, which will be administered by the Board of Horse Racing, the Gaming Commissioner shall administer the provisions of this ordinance and shall have all powers necessary therefor. Section 11, subsection A, authority to license. With the exception of pari-mutuel and simulcast racing, which will be licensed by the Board of Horse Racing, the Tribal Gaming Commission shall have the sole and exclusive authority to license and regulate Class 2 and Class 3 gaming operations on Crow Indian lands which are now and may hereafter be permitted by federal law and a compact. Section 30, regulation and inspection. With the exception of pari-mutuel and simulcast racing, which shall be regulated by the Board of Horse Racing, Class 3 gaming shall be regulated by the Tribal Gaming Commission, which shall adopt all necessary and appropriate rules and regulations for Class 3 gaming, included but not limited to.
Thank you, Vice Chair. With that, that's reading by the sponsor. Now we go into the 30-minute presentation. Oh. I believe if there's no 30-minute presentation, then you just go right into and ask for the chairman of the gaming committee, what his recommendations are at this time.
Thank you, Speaker, Secretary, Vice Chairman, members of the body, and guests. We had a meeting, my first meeting dealing with this as the gaming chairman. We met on January 9th, and we spoke with the gaming commissioner, and we talked about it, and we're going to leave this in committee, but we're going to start looking into this and maybe look at a special session here pretty quick. So my recommendation is putting it back into committee.
Okay, thank you. So that's been referred back to committee. At this time, it's 3:45. We moved items 4 and 5 on the agenda to the end, which is approving the journal. So at this time, okay, floor organizes Senator Not Afraid of the Las Vegas District. Send it to committee.
Do we need a motion to send it to committee? It was just now read into the record, wasn't it?
Yeah. At that time, when I call for the recommendation, it's up to that committee chair to either give approval or disapproval, or else refer to committee. So it's only a recommendation, so do we need to vote then?
I make that in the form of a motion,
All
Mr.
right.
Speaker, to
All right.
send this item into committee.
Okay, we got a motion to send to committee, second by Senator Railbird. Do we have a question by Senator Gozet? All those in favor of sending this to committee, raise your right hand. With a vote of 14 yes, and 0 no, and 0 abstaining, this item will go back to committee. That takes us to the next item on the agenda, which is review and approval of the journal. Has everyone had a chance to review the journals for quarterly 2012 session, November 2012 special session, December 12th special session, and December 20th special session? Floor organizes Senator Not Afraid of the Lodge Grass District.
Thank you, Mr. Speaker. Members of the body, at this time I move that we approve, accept as written, the journals. Thank you.
We have a motion. We have a second by Senator Coversup. We have a question by Senator Railbird. All those voting for approval of the journals for October 2012 quarterly session, November 2012 special session, December 12th, 2012 special session, December 20th, 2012 special session. Raise your right hand. With a vote of 14 yes, 0 no, 0 abstain, the journals are now approved. That brings us to reports. And at this time, we are at the legislative branch, Speaker and Secretary of the House, and then committee chairs. Well, here's floor recognized Senator Stewart.
I just got a call from the Secretary's office. They're waiting for an email, I believe. I guess they're waiting for an email from Jackie concerning that. The cabinet heads are squirming. They're trying to get over here to make their reports. I guess it's going to be tomorrow, right?
Yes,
Okay.
I told them tomorrow.
So they need an email so they can forward it to the cabinets, and they wanted to know what the standards were, but you provided that LR, so I think that's the
Okay.
guideline.
All we want is the truth.
the truth will come out tomorrow.
What we can do is,
They want to know if they should come here by 10. I guess Jackie could forward that in an email. And there was really never a set time. I guess they want to know if they should just come in at 10, wait their turn.
that'd probably be the best. Senators, if we could just get here and get started right away, we can finish up by noon tomorrow, because we can just do reports tomorrow. If that's okay. Judicial is at 1, right? So we can do executive, have lunch, and then finish up with judicial, and then we're done with the session. Is everyone okay with that? And we do need a quorum to adjourn tomorrow. So, I guess with that, we'll start out with our reports tomorrow while they start getting their stuff together. So we'll begin tomorrow's session with speaker and secretary's reports, and then the committee reports for organized Senator Alden.
On that, do we actually have to have a quorum to start reports? Or I mean, from what like we start in the morning, just keep going, and then let's hit that quorum and adjourn? Almost, I'll ask my question, do we need a quorum to start reports? In order to call session to order, we have to have a quorum.
In order to have everything on record, we do have to have a quorum. What we can do, if you guys want to, we can do speaker, secretary, and committee chairs right now and get that out of the way. Well, I guess she has to go, so then we're gonna be without a quorum. Let's see, how many? Oh wait, we got 14 now. You gotta go? So that'll take us down to 12. Well, let's just do this. We'll recess until tomorrow. We've got 2 senators that need to go after kids. So we'll recess until tomorrow, and then we'll just finish up with our reports tomorrow. So grandkids and kids. So tomorrow, we'll say 9 o'clock, so we can all get here, get them done. If we can get our executive done right away before noon, I'll get in touch with judicial to see if they can get here before noon, because there's usually a fairly short report as well. We'll try to finish up before noon tomorrow. Is everybody agreeable? Okay. All right, we'll recess until tomorrow then.
And now you do.
Dana's trying to object.
Okay.